Hi, my name is Robert Chelle with Chelle Law, and my law firm assists professionals with employment contract and independent contractor issues. All right, today I'm going to talk about whether you can work for a competitor if you've already signed a non-compete with your current employer. The answer to that is it depends upon the language and the non-compete. So in Arizona, and for any state where non-competes are enforceable for that matter, there are three components to any non-compete. You have the scope. So what is it prohibiting you from doing? The temporal restriction, so how long it lasts. And then the geographic restriction, in what area can you not practice your profession? And so let's kind of break down each one. So most non-competes will state specifically what you can't do. So it's important for a number of reasons. Let's just say you're a doctor. You don't want the non-compete to say you can't practice medicine within whatever, for how long, and whatever the geographic restriction is. Let's just say you're an internal medicine physician. Well, you have other options. You could do urgent care. You could do primary care. You could do work in the ED. You could be a hospitalist. You have a bunch of other options. And so you want the non-compete to be specifically tailored to what you're doing for that employer. So if you're a hospitalist, you want the contract to only stop you from being a hospitalist within the restrictions. And then let's just say you're in sales. You are in software sales. You don't want the non-compete to say you can't work in sales at all in any industry. You want it to say you can't work within software sales, and even more specific to what you're doing would be better. And that way you have other options. Anytime you're negotiating a non-compete, it's always about giving the professional more options once the contract is terminated. And those options are other industries or potential areas of practice that you can get into for that short period of time, shortening the length of time that the non-compete lasts, and then obviously shrinking the geographic area where you are restricted from practicing. So the second thing, as I stated before, is the time restriction. Most Arizona courts have held that 1 year is a reasonable amount of time. Anything above that could be iffy. It does take into account kind of the totality of the non-compete. So they'll look to, all right, what is the scope of it? How long does it last? What's the geographic restriction? And so maybe a non-compete has a very small geographic restriction, but maybe it's a little bit longer. On average, the court may say, well, this evens out and we would consider this reasonable. There is no specific statute or code in Arizona that says this is exactly what a non-compete has to say. Here's the length it has to be. Here's the geographic restriction. That's not how it works. The courts have had a number of physician-related non-compete cases. Farber is the name of one of the main cases, and they found that 1 year and 5 to 10 miles from the physician's primary practice location was considered reasonable and enforceable. And then lastly, the geographic restriction. This also varies greatly depending upon what you do. For a doctor, 5 to 10 miles from 1 to 2 locations would be considered reasonable. If you're in sales, it could be an entire county. It could even be large swaths of the entire state, might be considered reasonable as well. It's just dependent upon what you're actually doing for that specific employer. Now, to get to the question of can they stop you from working for a competitor, I guess that question would mean you have a non-compete that simply states you can't work for company X, and it has nothing about what you can't do or for how long or in what specific area. Most of the time that it would very likely be unenforceable. However, I can't say that with absolute certainty because it would depend upon the employer. So if the competitor just has one physical location and it is, within a certain geographic radius, okay, that might be considered a reasonable request. There are plenty of healthcare contracts that state the physician can't work for X healthcare network for the restricted period, regardless of where they're located. Whether that's enforceable or not, I don't know. But if it says you can't work for an employer who is, has hundreds of locations throughout the state, would completely knock you out of the entire state. Well, no, that most likely wouldn't be considered enforceable. It gets trickier when you get into sales, because sales can be anywhere, especially when you're doing, kind of software related things and not hardware related. Those get tricky because you could theoretically sell to anybody anywhere within the state. Whereas if you're a doctor, unless you're doing telemedicine, you got to physically be somewhere. And so it's easy to carve out the geographic restriction for them. So can they stop you from working a competitor in a non-compete in Arizona? Yes, they can. However, it has to be tailored narrowly, and then each situation has to be taken into account. If you have any questions about your employment agreement, independent contractor agreement, or non-compete, feel free to contact my law firm at the phone number listed below in the description, or you can reach us through our website, ChelleLaw.com. If you thought this video was helpful, we have a ton of other videos on non-competes. I suggest you check those out in our channel. All right. Appreciate you watching the video. Thanks.